Bangazitha.
Well, thank you, Honorable Chairperson. Good evening, Advocate Batohi. I was looking at your statement, your press statement, which you issued on the 5th of June, and where you were actually expressing a very grave concern about the possibility of the NPA being infiltrated. To me, that tallies well with the assertion that Lieutenant General Mkhwanazi actually expressed also during his press briefing. Now, I'm interested to know what steps you have actually taken to deal with this concern. In fact, you even said that you do not sleep comfortably at night because of this. What steps have you taken to deal with this matter?
Thank you, Honorable Bangazitha, for that. As I explained earlier, I immediately upon receiving the information contacted the minister and advised her that I had needed to meet with her urgently. We then met the same week and I briefed her about it. I also briefed the president about it sometime after that when he was available and expressed my concerns about it. And that was about as far as I could take it, because this was intelligence that I received. But internally, as I mentioned, I went on visits to prosecutors across the country. Firstly, commending them for the incredible work that they're doing, because I can only imagine that I'm hoping that it's not, a large group of prosecutors, and, urging them to still make sure that they do what they are mandated to do in terms of the Constitution. And that I even said to them, we are citizens of this country. We have a right to vote. But like family members, when you have a case to decide upon, you decide on the evidence and nothing else. And so it was, those are the steps that I took. But there's nothing further that I could have done in these circumstances.
Well, thank you, Advocate. But also, arising from your response, it actually immediately draws my attention to what you told us earlier, that you are actually getting some in-kind type of support or donation from a foreign organization. Is that not actually also opening a slight opportunity for infiltration to happen under the guise of supporting your good cause as NPA?
As I explained earlier, Honourable Member, firstly, the support, in-kind support, is not from a foreign organization. It's from a foreign government. And we have ensured that the support we get is controlled by the NPA. We decide on the kind of support that we need. We have sat down and developed modules for training. So it's completely in the control of the NPA. So there's no possibility of this kind of influence, improper influence, being exerted by any organization or entity because of the fact that this matter is completely controlled by the NPA.
Well, thank you. Advocate, I'm not sure whether you also do the vetting of your employees and also do lifestyle audit for all your employees at various levels to actually, one, guard against the infiltration and also to be vigilant against issues, possibility of corruption.
Thank you. Those are really important questions. Of course, vetting is done by the SSA. And as far as the NPA is concerned, we are fully compliant in terms of all the requirements that need to be submitted to SSA for vetting. And as far as the lifestyle audits are concerned, the President announced lifestyle audits for public servants. That is a very, very welcome development. I agree, there needs to be lifestyle audits for NPA staff at all levels, starting with the National Director. And it is something that we've engaged with a number of institutions like the SIU, the Public Service, to look at what they're doing and what we could introduce in the NPA. We are in the process of developing policies around this because you need to have a framework to deal with this. I do want to add, though, it is a very expensive exercise. It doesn't mean we won't do it, but I'm just alerting the committee to the fact that there will be a need for an increase in funding to deal with this. But internally, I have spoken to, we've been discussing the issue and how we do it. I think moving forward, after we do certain categories of maybe high-risk persons, that we start off with certain categories, and then later, as a matter of policy, the NPA should have like a random selection of people that are, so you don't have to do everyone every year, but there must be a process whereby Shamila Batohi can be selected for lifestyle audit this month. Next month, it's somebody else. So there's constantly, you don't know when your name will come up, but it could save costs and certainly make people vigilant that there is this process. So we are looking at various options to ensure that the NPA is in fact doing what it should be and is above reproach.
Thank you. I would refer you to your statement, especially paragraph 71, where you gave a figure of 58. What is that? Complaints of allegations of corruption. I was wondering if you could actually give a provincial breakdown of that figure so that we have some kind of a view of where the problem could actually be.
That is certainly possible. I don't have it with me now, but we can certainly provide that information.
Okay, thank you. You will agree with me that of late the NPA has taken a lot of, should I say, criticism from South Africans, especially for moving with a snail's pace insofar as the prosecution of cases emanating, in particular, from the Zondo Commission recommendations. And your defense has always been that, you have the issue of resources, the budget. You also we are busy with the institutional transformation. Can you share with us your experiences and the impediments that stands in your way that could be actually attributed to the delay in the finalization of your institutional transformation?
Thank you. I think we've gone a long way in terms of institutional transformation. There have been many initiatives that we have undertaken to enhance the the institutional reform within the NPA. And the challenges with regard to addressing particularly complex corruption matters is something that we must understand, that we are coming from a time when institutions were deliberately weakened and we didn't have the capabilities, capacities to deal with these challenges of investigating complex corruption matters. And the Zondo Commission sadly did not give us a blueprint for prosecutions. The standard of proof, as I said, in the Zondo Commission is very different to a criminal standard. And so in order to ensure that we met the criminal standard for prosecutions, we have, in the past 4 years, and that is post-COVID, and also understanding, as I explained earlier on, the IDAC only became permanent in August last year, when we were really able to have a proper structure to identify the necessary capacities, capabilities, disciplines, and to start recruiting in order to ensure that these cases can actually be dealt with very, very quickly. So it's really important to understand that these challenges with regard to skills, capacity, etc., we are only able to really start dealing with them after the IDAC became permanent. Prior to that, we are dealing with trying to address these matters in a broader system that is not functioning optimally, where we do not have the skills, capabilities, capacities to deal with these matters. So I think it's important to understand that in the past year, and to be frank, the fact that the IDAC has, notwithstanding these serious constraints, has enrolled over 50 cases, has over 300 entities and individuals before courts already, some of them very high-profile persons. And as I mentioned earlier, some of the key Gupta lieutenants are in state capture already, implicated allegedly in state capture, are before courts. So there's a number of these matters, and I dealt with it when Honorable Breitenbach raised these, the fact that it hasn't moved through the system, the court system, quickly enough. So the country says we don't have people in orange overalls or convictions. The fact that there's over 300 entities and individuals in court and it's not moving through to the system for us to have finalization means we have to look at the institutional challenges within the court system that hamper our ability to deal with these matters efficiently. I do want to state and emphasize again that we have, with regard to the Zondo, the 51 cases that are before court at the moment, they are dealing with 127 recommendations from the Zondo Commission. And I also want to make the point about asset recovery. Asset recovery is a very important aspect of accountability. There's two parts. One is prosecutions and convictions, justice, finalization, maybe imprisonment or whatever the consequences are. And the other aspect of the strategy is bringing back the stolen money. And the asset forfeiture, we've had a deliberate, intentional strategy to actually proceed in terms of Chapter 6 of the Prevention of Organized Crime Act, which is not dependent on a conviction, because we realized how the tactics to delay cases moving through the system can hamper our ability to bring back money. Chapter 6 is not, I don't want to go into too much of technical detail, but it's not dependent on a conviction. And that has resulted in us bringing close to 50% of all recoveries in the past 25 years have been brought in the past 4 years. And that demonstrates our focus on asset recovery as part of the strategy to deal with corruption. I think the other issue that we really need to deal with in terms of trying to deal with corruption is the issue of protection of whistleblowers, which I mentioned earlier. It's a very, very important aspect in terms of trying to address corruption.
Well, thank you. Well, I know that the issue around the arrest of Lieutenant General Kumalo has actually discussed quite extensively, but I can't resist the temptation of wanting to find out from you that Lieutenant General Kumalo, as we all know, is National Head of Crime Intelligence. And in this instance, together with his entire team, is arrested. And that actually is a blow to the national management of the country's crime intelligence. Now, did it occur to you that the national security might be actually compromised by the arrest of this top management of our crime intelligence?
In terms of how the ID assessed it, I think in their view, they saw a greater threat to national security with the situation that was unfolding in terms of their case theory with regard to the recruitment of people for specific reasons. And so the IDAC, the ID, has explained that this was part of a much larger case strategy, that this is one of several other matters. And so in their assessment, this was in fact in itself a risk to national security, so they needed to proceed on this matter.
Surely this is a crisis situation for the country. I would have expected that this development would be actually taken to the higher or even the highest echelons of the leadership of the country. Did you inform the president of the country about the impending arrest of the top criminal, the crime, what is that? Crime intelligence people?
I did not
Was the president informed about it?
I did not inform the president of this.
I beg.
I did not inform the president.
Is there any particular reason? Because I would expect that the president would need to be actually put in the loop about these developments.
I think with hindsight, you're right. The president should have been informed of this.
Advocate Johnson, who is the leader of IDAC, in my view, also committed the same offense as Lieutenant General Kumar, by actually presiding over the process to employ her husband. What have you done to deal with this? I know that is 20 years ago, but wrong is wrong now or 100 years ago. That is why the Nuremberg trials are still taking place 70 years after the World War, or even.
And that is why we are still prosecuting people for TRC-related cases 30, 40 years after the commission of these many offenses. So I agree with you. But the circumstances are very different. And one has to look at the context of this matter. In my view, Advocate Johnson made an error of judgment at the time. And the circumstances are extremely so far apart that it cannot be compared. You got to compare apples with apples. In this case, we're not comparing apples with apples. She didn't do anything close to what is alleged in this case. Excuse me.
Your Honorable Advocate, when Lieutenant Mkwanas was here, he told us that actually Lieutenant General Kumalo did not employ the person in question. He merely presided over a panel that was actually interviewing, but the actual appointment was done by another panel, which has not been arrested. Could there be any reason why they have not been arrested if employing that particular individual was a crime?
Honorable Member, with all due respect, when one looks at one simple fact, it may not appear to be amounting to a criminal act. But in order to decide whether a crime has been committed or not, one has to look at all of the evidence before the investigators. And so this is one allegation, but it's not all the evidence. Clearly, all the evidence would have justified such action in the circumstances, and we have to consider all of the evidence. I want to really emphasize that.
Well, then we were deprived of that information because the issue that kept on coming up here was the issue that Lieutenant General Kumal presided over the employment of a particular individual, which was the major charge. Okay, but I'm no longer there.
If I could respond to that, Honourable Chair,
okay.
through you. I again emphasize the fact that there is a review process available. And I would urge that if anyone is aggrieved by this decision, that they invoke the review process so that the matter can be considered by the National Director.
I'm not sure whether you are aware, Advocate, of a bad relationship between Advocate Johnson's husband and that of Lieutenant General Kumal. And we learned that Mr. Johnson actually works under the supervision of Lieutenant General Kumal.
I'm not aware of a bad relationship, and I do believe, I think Advocate Johnson was asked about this question, but I want to emphasize again that if there's an insinuation that the reason for this case is that bad relationship, that is not the case, because as I explained earlier, this case came to the attention of the IDAC through a Section 27 referral. Had that referral not been made, this case would never have seen its day in court. So I think it's very important to understand the circumstances under which the IDAC became seized with this matter.
Lieutenant General Mkwanas actually strongly believes that the arrest of Lieutenant General Kumalo and his team is actually motivated by none other than the work that they are doing in actually investigating and arresting the drug and criminal, syndicates in Johannesburg. What would you say to that?
There's absolutely no way the IDAC would arrest people in order to subvert an investigation into organized criminality. I can lay my head on the block that the head of the ID, Advocate Johnson, will never allow or be in any way inclined to act in that manner at all. So I want to dispel that notion very strongly that that would have been a motivation for the arrests in this matter.
My last question, Honorable Chairperson, is just to find out how endemic is the problem of factionalism within the NPA, Advocate, if any.
I don't know how endemic it is, but with the leakages of information that we experience, I I do believe that there are elements within the NPA that, as I said in my media briefing, not media briefing, in my interview, that may not be fully committed to the mandate, objectives of the vision, mission of the NPA. But how endemic it is, I don't know. But that's why I urge again, there's an absolute zero tolerance to prosecutors who do not abide by our code of conduct. One thing we do not do in the NPA is we do not sweep things under the carpet. When there's an allegation, matters are fairly investigated, there is a process, and there will be consequences. So again, I urge members of the public, members of this House, if you have any information with regard to prosecutors that are not acting as they should, please send it to us.
Do you still have questions, Pangazita? Yes. If you have exhausted
the
your
last
questions,
question. Advocate, my concern is actually around the lack of communication, interaction, and actually sharing of ideas, sharing of information between and amongst all the units that are there in our criminal justice system. At one point when we were actually discussing issues with IDEC here, there was an incident which was reported whereby IDEC operatives or investigators actually demanded files or dockets which the other unit were actually busy investigating, to a point where IDEC had to subpoena those dockets, and they were hand-delivered by the National Commissioner after they had been subpoenaed. To me, that was a glaring, example of lack of communication, because why would IDEC, subpoena dockets when the police, another unit of the police, actually was busy investigating, doing some work on them?
Advocate Johnson dealt with this aspect in a lot of detail, my recollection is, and I don't have the detail of what, but my recollection is that she said she did communicate with the National Commissioner and various other heads in the police. And I want to, make the point that invoking a legal process where you communicate and then sometimes to protect a process, it is or the information, it's sometimes better to invoke a legal process, but not in the abstract. After you speak and communicate with colleagues and it's understood why the legal process needs to be invoked. So I think that's, in the circumstances, Advocate Johnson explained how it came to the Section 28 subpoena. But I want to say I agree with your point that it's critical that as law enforcement we are engaging, we communicate, we share information, and we work together. The sad reality is, with what you are hearing in this committee and in the Madlanga Commission, you begin to wonder who do you trust and how do you share information? And that is maybe one of the reasons why investigative teams are becoming so guarded with regard to sharing of information, because one leak within a team is enough to destroy the entire case. So it is a challenge that we're facing, but I agree in principle that there needs to be a lot more coordination and sharing. It's not like it's not happening, but it can be improved.
Thank you, Honorable Chairperson.
Thank you so much. Honorable members, allow me to take Honorable Souls. We will take follow-ups thereafter.
Thank you, Chair. Until what time? I think it's 2040.
It's up until 20 hour 42.
Thank you, Chair. Good evening, Advocate. Honorable James, may I ask for you to just shift on the other side? I can't see, if you don't mind. Thank you so much.
Did she hear you, Honorable Sir?
Clearly, she did. So, van elders up, Chair. Said I, warm a car. Advocate, General Mkonazi testified that he ensured that there's criminal charges laid against Mr. Mdluli. And he testified and made an allegation that the NPA at the time, represented by Honorable Breitenbach, that's the only name he mentioned, and others, withdrew the case, the criminal case against Mr. Mdluli, who was the then head of crime intelligence. Is this true?
I don't have personal knowledge of it because I wasn't in the country at the time either. So I don't know who withdrew the matter in court.
Section 22, I think, subsection C, 2C, gives you power to review matters such as this. Are you saying that you haven't looked into this matter?
This matter has a long history, and the Mr. Mdluli was subsequently charged. He is currently facing, I stand to be corrected, but he's currently facing various charges, commercial crimes, economic crimes, fraud is being one of them. And in respect of the other matter, so those charges are still being heard in court. With regard to the other matter where he was charged with, where a decision was taken not to charge him with murder, he was instead charged with, I think, kidnapping, assault with intent to cause grievous bodily harm. I don't have the charges in front of me, but that's how those two matters are being dealt with.
Now, given your mandate, I understand that you have not looked into that matter, or you don't know much about the matter because at the time you weren't there. But given your mandate, the moment you heard the allegations against the NPA by General Mkonazi, that should have been enough reason for you to then delve in detail into this particular matter, because he was very specific about this particular allegation. Did you do so?
I couldn't in the circumstances because he is facing those charges.
Yes,
they've been re-enrolled.
Yes, but I'm saying, are you testifying that you are fully aware of the matter? Because I want to talk about it.
I am aware of the matter.
Okay.
Whether
great.
I'm fully aware, I'm not sure, but I am aware of the matter.
Okay, great. So, General Mkonazi only mentioned Honorable Breitenbach in his allegation. Who else was involved in allegedly withdrawing the fraud and corruption case against Mr. Mdluli?
I don't know for a fact, as I say, because I was not here, but my understanding is that it would have been potentially the head of the SCCU at the time. The matter was, I don't know. I can't speculate. I want to tell this committee things that I factually know, but it could have been, I think Advocate Chauke was involved. I don't know whether anybody else and who in that office would have been involved in that matter as well.
So it would be Advocate Chauke, you correct, and Mr. Jiba. And I was wondering whether there's others that you do know too, but you don't, so we'll continue. So the Supreme Court disagreed with this group, with their decision in the NPA to withdraw criminal charges of fraud and corruption against the head of crime intelligence at the time. Does this fact that the court decided against the NPA decision, does it mean that the decision by the NPA to withdraw amounts to interference or defeating the ends of justice?
It could potentially amount to defeating the ends of justice.
Why potentially and not it does?
That's a good question.
You have a good answer?
I hope so. I'm thinking about this. I think it would amount to attempting to defeat the ends of justice.
Are you testifying that the NPA, with this decision, defeated the ends of justice?
I wouldn't say the NPA, but I would say individuals in the NPA.
I'm not sure you can separate because they acted within their capacity as officials of the NPA.
That is correct, but you cannot impute the conduct of one or two individuals to an entire organization of close to 5,000 employees. But individuals responsible must face consequences.
Those individuals in senior positions would then impact on the integrity of the NPA. It casts doubt on the integrity of the NPA, would you not say?
It certainly is an issue with regard to integrity of the people involved. But again, I emphasize you cannot impute the lack of integrity of a few individuals to an entire organization with people that of the highest standards of integrity. But the individuals concerned must certainly face consequences. There must be a fair process and there must be consequences.
You see, Advocate, the allegations before us is that there are elements within the NPA that is involved in defeating the ends of justice. So that allegation would then seem to be true if you say that indeed this action amounts to defeating the ends of justice, and it is the NPA.
It is, I emphasize, individuals in the NPA that must face consequences. At the time when this happened, I was not in the country. I'm not saying, I want to make it clear that these things happened whilst I was abroad working. And now we are trying to deal with these matters so that there are consequences.
Okay. Are you using your Section 22C mandate or power to review, to look into this matter again in detail, given the allegations made public? Because this happened since 2015. The court decided that the case should be reinstated. In 2015, the NPA decided to do so. It is 10 years later. 10 years. Is Mr. Mdluli, 10 years later, convicted and in jail for this criminal matter of fraud and corruption?
I do emphasize, I agree, it's 10 years later. And these were, these events took place during the state capture era. And we have been trying to remedy and recover from that in the past 6 years. As I said, the matter's been re-enrolled and is in court.
So your answer is no.
My answer is no for those reasons.
Our research shows that Mr. Mduli was sentenced for 5 years in September 2020 for another crime, not this one that we're discussing. He was convicted and sentenced for 5 years for kidnapping and assault that he committed in 1999 when he was the station commissioner at Vosloorus. Is this true?
That is correct.
Does this mean that we had a criminal as the head of our crime intelligence at the time?
That is correct.
He served 2 years of his 5-year sentence. 2 years. He's now, as we speak, he's on parole. Was this because of political intervention?
I have no knowledge of that. The parole, NPA has got no role in the parole process. It's dealt with at correctional services.
When we look at your witness statement, Section D, page 21, paragraph 57 and 58. Are you there?
Sorry, the paragraph number?
57 and 58. Are you telling us as the committee that in order for us to understand the relationship between the MPA and the PKTT, we must go listen to the Madlanga Commission, to the testimony of Advocate Harrison, the DPP of KZN?
No, I'm not saying that. I simply set out the fact that she has led evidence there. But of course, if this committee wants to call her, that is the prerogative of this committee.
But you were informed, Advocate, that we want to know about the biggest allegation is that the relationship between the NPA and the PKTT has broken down. There's been major allegations. So we had to hear testimony from you around the details of that. Do you disagree with that allegation or not? You have an entire section entitled The Functioning of the Criminal Justice System Value Chain and the Role of the PGI. So when I saw the heading, I thought, now what I'm going to see is you are going to now deal with the allegation that there is a breakdown in the criminal justice system value chain. And you were going to go into detail within the allegation. But then when I came to these two paragraphs, you are telling me, in order for me to get the details, you are not aware, you don't have direct involvement, so you can't talk to the detail. I must basically go and listen to the Madlanga Commission to get the details, because in your affidavit, you don't deal with it.
With all due respect, Honourable Member, that's not what I'm saying, that this committee should listen to what's happening, what has been testified in the Madlanga Commission. I cannot testify to that relationship because I've not had a relationship except for what I mentioned in my, when I was being led with the PKTT. And so this committee wants to get first-hand knowledge. It's important that you get it from the person that was in the NPA engaging with the PKTT. And I do want to say that to the extent that the committee wants to hear it, but in the Madlanga Commission, the DPP of KZN testified that they had a good relationship with the PKTT, pending some teething problems at the beginning. But she would be best placed to deal with that.
The approach should have been, based on my understanding, because you are testifying, that you would then have had this discussion with her, because you know that one of the things within our terms of reference is the very thing that we are discussing. That's the very reason why you have a section dedicated to it. But this section doesn't deal with the details. It gives us a high level. But it's fine. Let's attempt to go into it then, to deal with what I would have expected you to deal with. So you give a high-level explanation of PGI, but you're not testifying on the allegations that are made by General Mkonazi of the breakdown between the criminal justice system value chain. So do you believe, as the main witness has testified, that there is a breakdown in the criminal justice system value chain? Do you believe that or not?
Honorable Member, that's a very, very broad question. And there are some things that are working in the system and there are other things that are not. Specifically with regard to the PKTT, I don't know in what context the evidence was led that there is a breakdown of relations. So I can't comment on that unless I understand exactly what was said and what was meant. And then I can potentially comment on it.
Well, he was basically saying there was no communication between, based on the PGI model. There has to be this open-ended, this open, transparent communication, and you would know when arrests would happen, etc. So he was making the allegation that because there's a breakdown, this is why the IDAC, to protect, this is the allegation, to protect drug cartels in Gauteng, they then used that as a smokescreen to arrest, they used the arrest of General Khumalo as a smokescreen to protect the drug cartels in Gauteng. So do you see the depth of the allegation? Therefore, I expected you to go into detail in this section and then explain, do you agree, do you not agree, and why not? But we're talking about it now, so.
That is a very, very dangerous allegation to make, that a law enforcement agency that is mandated to deal with corruption and other related offenses would effect an arrest in order to protect drug cartels. As I answered earlier, I have no doubt that the IDAC and the ID would never, Advocate Johnson would never be motivated. She is a woman of integrity. She may have had errors of judgment in her youth. She's a woman of integrity, and I have no doubt that she would never effect an arrest like this in order to protect drug cartels. That is a dangerous allegation. And the Advocate Johnson said she was not even aware, if I recall her testimony. She had, that General Khumalo was part of the PKTT when they effected the arrest. They knew he was the head of crime intelligence, so she didn't even know about that link. So that is just a bizarre suggestion. And it would be good to understand from the person who made that allegation on what is the basis for that. And I would definitely want to understand that, so that if there's any chance that it might be true, I get that information and we can deal with it. But I have no doubt that that is an incorrect speculation or assumption that has been made.
So you disagree?
And the other point I want to make is that, yes, sorry, to answer you, I do disagree strongly. The other point I want to make is that the DPP in KZN, in fact, testified that there's a really very good working relationship with the PKTT. And that is where they were, in fact, the Political Killings Task Team, that is where their work, in fact, centered in KZN. And her testimony has been that there has been a very good relationship working with the PKTT in KZN.
And that is exactly the point. As I'm listening to you, you're saying, one, the IDEC head, Advocate Johnson, is a woman of integrity and she would never do something like that. You then testify that the head, the DPP in KZN, testified in the Madlanga Commission that they have a very good relationship. In other words, the DPP KZN knows that General Kumalo, which is now a central figure in the investigation that IDEC is undergoing, the DPP KZN knows that he is coordinating the PKTT because they are working together with the PKTT based on your testimony very well. Correct?
That's correct.
So Section 24, subsection 2 of the NPA Act says that it's mandatory to have jurisdictionary consultation with the DPP when dealing with a case such as that IDEC has done. My understanding of that, are you aware of the section?
I am aware of the section. I just haven't opened it. My recollection is that, well, I should get the section open, that it is the DPP in the jurisdiction where the IDAC is going to enroll a matter that consultation needs to take place in. And in this case, it wouldn't have been KZN. It would have been the DPP in Gauteng.
Yes, but what it also speaks to is the consultative process because of the model of PGI, to say that if IDEC is thorough, what they would have done is look into who their core subject is, which is in this case General Kumalo. And one of the things they would have found out is that General Kumalo is coordinating PKTT. And to find out more about that part of the subject of investigation, they would then have consulted with the DPP. This, why I'm saying this, Advocate, and you can help me, why I'm saying this, it's because it is shocking that this is provided for. If IDEC has done this, then Advocate Johnson would not have testified that the first time she heard that General Kumalo coordinated PKTT was on July 6th. If she followed the model of PGI and consulted with the DPP in KZN, she would have not been surprised on July 6th to find out that General Kumalo is the head of the PKTT. Do you think that it speaks of competence and it is okay in the scheme of things when you provide oversight that the head of IDEC, who's investigating a subject, only finds out when General Mkwanazi makes an announcement on the 6th of July that the same person they are investigating is the head of the PKTT?
Thank you. I want to be clear that Section 24, it is a requirement of the IDAC when you are enrolling a matter to consult with the DPP in the jurisdiction where the matter is being enrolled. And this is an important factor because the honourable member is linking this to a legislative requirement. And it's important that the requirement is clear. The DPP, the IDAC is expected and required to consult with the DPP in whose jurisdiction the matter is going to be enrolled. And in this case, that would have been the DPP of Gauteng, not the DPP of KZN, where the PKTT was conducting most of its work. Now, the point of prosecutor-guided investigations, the IDAC follows the prosecutor-led investigation model, not PGI. PGI, as I explained earlier, is where the police, like the PKTT in KZN, works with the prosecutors in KZN, who guide their investigations, and they work together in KZN. So the IDAC was not actually involved in prosecutor-guided investigations with the PKTT or with any other unit in the police. I'm just trying to clarify so that the honourable member, if I can help, explain what the situation is.
You're definitely helping. And of course, I will take your position on the matter because you are the expert in the matter. But let's deal with why I'm asking the question. Is it appropriate for the head of IDAC to only find out about a subject that they are investigating? She only finds out about the fact that she knows that he's head of crime intelligence, but she doesn't know that he coordinates PKTT. Is that intelligence? Is that on that level of intelligence you don't know? Is that a good reflection of the capabilities of the NPA?
It's perfectly understandable that, as Advocate Johnson said, she had no idea that the head of crime intelligence was also involved in PKTT. In fact, one might ask the question, why is the head of crime intelligence actually a part of the PKTT? I'm not sure I understand that, but perhaps there is a good explanation for it, because you wouldn't expect the head of crime intelligence, who's got enough work in CI, heading up an important unit in the police. Why was this person involved in the PKTT? But I say there may have been a very good reason for it that I don't know, but it'll be good to understand that link. And the fact that Advocate Johnson, when they were dealing with this matter, didn't know that he was part of the PKTT is not that unusual. In fact, had she known, in all likelihood, she might have spoken to the DPP of KZN.
All right, so I accept that. Now I need you to explain to me, if you say that based on your experience and based on your oversight function, there's nothing wrong with her not knowing, even though on that level of intelligence that she operates on. I will accept that testimony. Now I need you to explain the flip side. Is my last question. You say that you are actually concerned that he's the head of crime intelligence, General Khumalo, and he coordinates PKTT. There has been testimony of this connection, that it all links. He's the head of PKTT. He's the divisional commissioner for crime intelligence, and then linked to the appointment of an unqualified person on the technical services side within the crime intelligence division. And the link then creates the impression that, and this was part of the testimony of Advocate Johnson, that the speculation is that this link is so that there is a network in order to be able to have control over access to funds, access to resources, such as the procurement of sophisticated equipment, etc. Are you of the same view that General Khumalo is strategically placed in this position, and the link to the person from BMW that was employed, plus his control over PKTT, is all interlinked in order for them to have control over the resources? Do you agree with that? Do you think that there are that's a valid position to take, or would you say no?
Well, the honourable member has raised two things. Firstly, I want to clarify that I didn't say I was concerned about the head of crime intelligence being involved in PKTT. I said I didn't understand it, but there may be a good reason for it. And that seems to have come through now. But as I testified earlier, the IDAC, the ID has explained that there is a broader case theory and that the capture of institutions happened. Recruitment was critical in state capture to ensuring that the resources of the state could be plundered. And that is the case theory in this particular case. Advocate Johnson has indicated that it was part of a much larger strategy. There are other cases. And so given that this is also, part of an investigation, and I don't really know the details, this is as far as I can take it.
Thank you very much, Advocate. And in closing, I want to say that your testimony here has revealed some deep levels of vulnerabilities within the NPA. Take accountability for it, deal with it for the time that you have left, because it's very concerning that it makes us vulnerable, that we have intelligence on that level that publicly says, I don't know. It then makes the security of our country vulnerable, and we should do more to ensure the security of our country. Thank you.
Thank you so much. Can I check honorable members who want to ask follow-up questions? Going. We are now at the third speaker. Honorable James, it's going to be your time. It starts now up to 20:55.
Thank you, Chair. Advocate, for the benefit of those who may not have seen the full request to the President, your letter that you wrote, what were the reasons you included in your request, in your view, that justified the suspension of Advocate Chauke?
Bear with me for a moment. So this matter is also the subject of an inquiry, which is commencing next week. I will be testifying at that inquiry and will set out in detail the reasons for it. But at a high level, what I can say here is that the reasons for it is that Advocate Chauke was not in compliance with the prosecution policy when he pursued a case against Major General Boyson with regard to racketeering charges when there was no evidence linking him to this matter. And also it relates to the withdrawal of the charges against General Mdluli when there was prima facie and strong evidence to the contrary. And those are the main aspects, and then some other decisions that were taken in the context of these matters.
Okay. The President only acted on your request, we all know this by now, July 2025, just days after General Kwanaze's press conference, alleging that corrupt prosecutors were aiding criminal syndicates, drug syndicates in Gauteng, right? Why do you believe the President waited almost 2 years to act on a matter raised by the country's top prosecutor 2 years later?
I want to say to the Honourable James that it was something that was out of the hands of the NPA, and as I indicated earlier, we certainly followed up to try to get the matter dealt with speedily. It was already, and there was nothing further that we could do. I indicated earlier that I do know that that there was a further legal opinion that was sought, which would have also delayed things somewhat. But apart from that, I cannot really say why it took that long for the decision to be made.
And during this time, what was Advocate Chauke doing? Was he continuing with his daily duties as usual, despite being connected to these cartels and to these persons?
Well, there's no allegation that he was connected to cartels in this matter. But yes, he was the DPP in South Gauteng.
And he continued, despite the red flags, he continued to do his daily work. And no one did anything.
I agree.
Only up until the 6th of June, when General Kwanazi made those allegations, suddenly, 2 weeks later, the president acts.
These are complicated processes.
Definitely.
And there are processes within the president's office, clearly. He needs to apply his mind to this. And one can understand why he might have wanted another legal opinion. And so I agree with you. It is totally unsatisfactory. It is unsatisfactory and potentially unfair for the individual and for the institution. And I've said this publicly, and that is, it was really important that this matter be dealt with speedily for both the individual and the institution. And I can't explain any further, but to say that I agree with you. It's not an acceptable situation to have someone under a cloud like this and still be conducting day-to-day work. But the reality is that is what, with these labor processes, we have to follow process. And it was what,
and it's coincidental that the process, a decision was taken 2 weeks after General Kwanazi's allegations. I think I'm stuck there.
I can't help you get unstuck, unfortunately, because I don't know
clearly
if it was linked at all. I can't comment on that.
Okay. Advocate, are you aware that former Johannesburg Mayor Herman Mashaba has repeatedly raised public concerns about Advocate Chauke, where he made clear that the Advocate Chauke was an obstacle to the prosecution of corrupt cases that were presented to him with clear evidence? Are you aware?
I'm aware he has made public announcements about this, but there's no case that he has presented to me where, if I heard you correctly, where maybe you could repeat the last part of your question, please.
Okay. Are you aware that former Mayor Herman Mashaba has repeatedly raised public concerns about Advocate Chauke, where he made clear that the advocate was an obstacle to the prosecution of corrupt cases that were presented to him with clear evidence?
I can't comment on that because I'm not aware, but I would certainly urge Mr. Mashaba to send me the details of those cases very urgently. In fact, if he can send it to me tomorrow, I would be very pleased.
Sure.
Thank you.
Here are copies of the many cases that Mr. Mashaba sent to you. You were CC'd in on these cases. A dossier was handed to Advocate Chauke of cases, I think, amounting to over 35 billion of corruption cases uncovered in Johannesburg. You were CC'd in all of this. I can give you the date, the 16th of May, 2029. You are now saying that you were not aware. I've just brought a few of them to this house to prove to you that you were CC'd in this case. You haven't responded to not any one of these cases. This was 4 years prior to your suspension. You received smoke signals already about Advocate Chauke, which you did nothing about.
I need to have a look at that.
Honorable James, you may come down a bit.
Thank you, Chair, for the reminder. I put it, you said earlier on that it wasn't brought to your attention. You said confidently you know nothing about it. I'm saying to you, 4 years prior, the suspension of Andrew Chauke, there were smoke signals. It was sent to you with evidence, with serious cases within the city of Joburg, and you ignored all of these emails.
Now that you prompt my memory,
Okay.
he did send emails, and we certainly don't ignore emails.
But you just said you weren't aware.
I need to follow up and to see what happened to those matters.
I can tell you nothing happened.
If I could please have those cases,
They're in
because
your inbox, ma'am.
we are, sometimes emails don't reach you, but in this case, I'm aware that he did send some communication, but I need to check to see what happened to that, because you may rest assured, Honorable James, we don't want to cover up anything. And if anything, I would want to get to the bottom of allegations that any prosecutor, any DPP is in fact not prosecuting where there's clear evidence of it. So I need to see what happened to that, because we definitely respond to emails, but from anyone, and particularly from heads of...
Yes, I would like to think that you would take an email from a mayor seriously.
We do.
You've ignored, you cannot say you do when I've got evidence and proof. Several emails, an entire dossier was handed to Advocate Chauke. He did absolutely nothing with it. It was highlighted to you that this person is corrupt. It was highlighted to you that this person is covering up for serious construction companies within the city of Joburg, Zimbabweans, with fake documents. It was brought to your attention, as well as Advocate Chauke, that is currently on suspension for over 2 years, that was allowed to continue covering up in the department. In fact, this has been going on for over 6 years, if you take into consideration when these red flags were highlighted to you. And you've done absolutely nothing. And then earlier on, you said that if there's any concerns with regards to cases, I must bring it to your attention. Will you take it seriously when you are saying to us now that sometimes we miss things in our inbox?
We always take these very seriously. And I want to say to you, I want to apologize to Mr. Mashaba that if he has not received a satisfactory response. But I do want to check to see what my office has done with those matters. And I can then give a more substantive reply.
I can tell you they've done nothing. But anyway, do you roughly know how many drug-related offenses have been handled by Advocate Chauke during his tenure?
No.
Are you aware of the conviction or the success rate in drug-related and other criminal matters prosecuted by Advocate Chauke's office in the South Gauteng division? Because that's where the bottleneck is when it comes to drug-related cases. South Gauteng division.
I don't have the figures, but we can certainly get that.
Okay. Would you agree that showing that Advocate Chauke frustrated the proper functioning of the criminal justice system in Johannesburg for so many years, that there may have been some plausibility to General Kwanazi's allegations that certain prosecutors in the same environment were deliberately sabotaged to protect drug cartels?
Before I can comment on that, I'd like to get details, proper details from General Mkwanazi about who he's referring to and what these allegations are about. Because they're just allegations, and I can't comment on allegations. I need the facts.
Thank you, Chair.
Thank you so much. We are moving to the last two speakers. That is Honorable Sangoni and Honorable Nomval. Honorable Skosana.
Thank you very much, Chairperson. It's been a long evening, Advocate Batohi. And maybe let me just start off by saying I'm a bit starstruck when Chairperson, I won't lie. I've admired Advocate Batohi's work for a very long time. I remember when she was trying the Hansi Cronje matter. There was this beautiful newspaper cover, where it was just her eyes, and then it says "in the eyes of the tiger." That was amazing for me, and I think watching you as a prosecutor and the work that you've done internationally, we really commend you for the great work that you're doing. So thank you so much. Thank you for making the time to be here. Advocate Batohi, just tell me, since July 6th, when General Mkhwanazi made these allegations, I know you've spoken now about things that you're trying to do, but what happened in the NPA? Were you shook at all in any way by these allegations? Was there anything that was done?
I think, like the rest of the country, we were certainly taken aback by the allegations. Since that date, I have not approached Advocate General Mkhwanazi or the police for details of this. But given that we have now testified, it's out in the open, I will address a letter to the National Commissioner seeking details so that we can properly understand what's going on and take the necessary action.
Okay. In paragraph 22 of your statement, you indicate, so you're talking there about the prosecution policy and how matters are decided, or at least what must be prosecuted. You then say that you refer to a matter of public interest as a consideration to prosecute or otherwise. So I'm just interested to find out, how is public interest determined firstly? And then are there any cases that you are aware of where public interest has swayed the decision to prosecute or not? And if you could share those with us, please.
If you give me one moment, Honorable Sangoni. My apologies for this. I did. This is. Oh, I wish I could find this. When dealing with public interest, it is an important factor, and it deals with aspects such as the gravity of the offense, the circumstances of the community, of the individual concerned. Generally, the courts have found that when there's allegations relating to a particular crime, it would be in the public interest to prosecute a matter. But there are instances where you would consider factors that I've just mentioned and come to a conclusion that it would not be. For example, an example that I might be able to give here now is, for example, a father who has been involved in an accident, and his child is killed in that accident, and the father is responsible primarily for that accident. You might consider everything and say, should we charge the father for the culpable homicide with regard to the death of the child? And then we would say, look, he's suffered enough. So those are some of the factors. I said the nature and seriousness of the offense, the interests of the victim, community, the offender's circumstances in some instances. So I think those are, there's no closed list, but those are some of the guidance that we give when we make these. But it's generally we lean on the side of prosecution, but we do consider those factors.
So there's no controversial, I use that word lightly, but controversial cases that you've chosen not to prosecute, and, prosecutors hide behind, it's in the public interest.
No, it's not.
For example, Agrizi.
For example?
Agrizi.
That was not my understanding, it wasn't a public interest matter, but it was the circumstances and the ID explained issues relating to him cooperating in other matters. So it was certainly not a public interest issue.
Okay. All right. Then on paragraph 83, you were asked a little bit about that issue where you make a recommendation to depoliticize the appointment of senior leadership within the NPA. Can you give us examples where this is done, perhaps in other jurisdictions around the world, and whether you necessarily think that that is a better model, given the fact that the politicians, at least that you have worked with, have given you space to do your work, even though you're appointed in the manner that the Constitution or the NPA Act outlines?
As I mentioned earlier, it's the fact that it is the president's prerogative to appoint the head of the NPA. Unless it becomes a Chapter 9 institution, I've said that there are very, very few jurisdictions, and in fact, none of them come to mind now, where there's some level where the executive do not appoint the head of the prosecuting authority, and there isn't some level of accountability to the executive. And that being the case, it therefore becomes really important for the executive to respect the independent mandate of the prosecuting authority, and for the prosecuting authority to understand its accountability and reporting functions to the executive, and that in this balance, the lines are not crossed. So, I think the president instituting the process to appoint, for example, when I was appointed, was a very good model to be adopted in terms of how a national director could be appointed. And that's the same model that's being now, it's the call for nominations, so it's the same model that's being utilized. I think as a matter of moving forward to enhance the system, it might be good to regulate this process. Although there's a tension between a president's responsibility to do it and legislating a process, that balance has to be struck. But I don't think that they are mutually exclusive.
Okay, so if I get you correctly, firstly, the way that South Africa appoints the NDPP in particular is nothing untoward. It's done exactly like that in many parts of the world. And then secondly, there have been attempts and steps that have been taken by the president in particular to make the process more transparent and accountable. Am I right?
Absolutely. And I think that's a very, very good model that the president has been following.
Okay. Thank you so much. Advocate Batohi, each time we speak about stalled cases, well, not that they're stalled, but cases that are not moving as quickly as we want them to be, we speak about the Zondo Commission in particular, the Nugent Commission, as well as the Mpati Commission, SARS and PIC. Do you have those matters in court as well? Because there were recommendations for criminal prosecutions arising out of them.
Yes, those matters are definitely in the mandate of the IDAC. I think the ID testified, and I stand to be corrected, that there probably are 3 matters from one of the other commissions. I'm not sure which one it is. But these are not a lot of matters. And again, I want to emphasize there's a lot more cases relating to the State Capture Commission in terms of the recommendations and the number of cases in court, the asset forfeiture processes. But given the capacity constraints in the IDAC, and again, the committee can help with that. If we really are serious about fighting corruption, we need to ensure that these entities that we create are not weakened, but are strengthened with the necessary capabilities, capacities, salary dispensations. And if we don't get that right, we are still going to struggle with moving with the required speed. But I do want to say that with all of the groundwork that we've put in place to capacitate, to make the IDAC, there was a lot of work that went into making the IDAC permanent, a lot of groundwork to capacitate. Things will move a bit quicker. The country will see it, but we still need to ensure that the IDAC is even further strengthened to be able to deal with the enormous amount of work that falls under its mandate. It's a lot of work, and there's just not enough capacity at the moment.
All right, now I hear you there. I'm really interested to understand what I thought sounded like frustration coming from you as it relates to how the SIU works. Now, I remember you said they're busy, writing reports, referring matters for prosecution, and those matters are not ready for prosecution. You think they should go to the Hawks, I'm assuming, for investigation. Why the Hawks? Is it not the responsibility of IDAC to investigate that? And then just generally, how is the cooperative relationship with the SIU and the NPA? Because a lot of issues end at SIU, we've referred the matter to the NPA, then you never hear much of it again.
As I mentioned earlier, we have appeared before SCOPA and other parliamentary committees together with the SIU and the DPCI, and given very detailed reports in respect of the cases. So it's not about frustration about how the SIU works. It's frustration about the process, because the Act currently requires that the SIU refer matters to the NPA. Now, prior to the IDAC, which with its limited capacity to investigate, all matters that were referred, in fact, went to the DPCI for investigation. And, it delays matters, but that's the process. But the Act says it must come to the NPA. And that, I said, should be amended moving forward. But you're absolutely correct that now that the IDAC has investigative capacity, there could very well be cases that are referred to the NPA that the IDAC takes over. But again, I really want to urge that the capacity issues are dealt with, because that's the way it should work. There are very serious cases that the IDAC should be investigating.
Okay, and then the SIU and the asset forfeiture unit, right? Because we've seen SIU attaching asset forfeiture attaches. Where is there duplication? Is it ideal that it's like that? I'm obviously, again, looking at issues of institutional reform. This is notwithstanding what the successes that you've spoken about, in terms of recoveries. But who does what?
That's a very, very important question. There are various entities in the system that have some kind of recovery powers. SARS has some. The NPA, of course, with the asset forfeiture unit has, and the SIU doesn't have criminal asset recovery powers, because that is in the Prevention of Organized Crime Act, and the NPA has those powers. The NDPP brings those applications. But the SIU has certain powers to recover damages. And so that's a really important issue, because I think this needs to be understood, and there needs to be an important conversation about who does what and where exactly should these powers lie. Because regret, and the NACAC has made recommendations, was looking into this aspect. And I think, again, I mean, in some context, I was saying that maybe we need to have, where everybody is everyone is fishing from the same pool, then it becomes competition amongst agencies, and it should never be like that. So, because there's enough corruption, but we need to be clear about who does what, clear mandates, so that at the end of the day, together, we're able to ensure that we collectively recover as much as we possibly can from criminals in this country. But that's a very important issue. NACAC's dealing with it, and there needs to be a lot more conversations about this.
In fact, I was going to ask you about the NACAC recommendations, because you did say that you support them, I suppose, in terms of the overall attempt for coordination. But can you just speak to us on this issue of whistleblowers? I mean, there's obviously lapses and gaps, and my understanding is that in order to get protection as a whistleblower, you need to be a witness in a SAPS matter, then they take you in for protection. But what needs to be done there, Advocate Batohi?
Honorable Sangoni, you're absolutely right. There's no legislative framework in our country for protection of whistleblowers. The department is looking at that very closely. And one of the aspects that needs to be dealt with, currently, you're correct, the framework only provides for protection of witnesses. And unless you're a witness in a criminal case, you do not qualify for protection. And that is a huge gap. The Department of Justice is working on that. And, hopefully that when legislation comes to Parliament, it will be fast-tracked. But, protection of whistleblowers is a tricky matter, because General Lubia once said sometimes whistleblowers come forward as whistleblowers, but they end up being suspects. And, but of course, the legislation needs to be drafted in a way that we are able to establish who the true whistleblowers are that need protection, because otherwise we're fighting a losing battle in terms of trying to address corruption.
Okay. If there's one thing that I know you've heard enough of today, is the matter relating to the arrest of General Khumalo. But I do need you to understand, Advocate, that why this thing bothers us so much is because we think that, well, let me not speak for all the members. I think that, it looks like a fight back strategy that is being adopted by those that General Mkhwanazi alleges are protecting drug cartels and all sorts of things. Now, you've been saying, and you've been at pains to explain to us that that matter would never have been handled by IDEC if it was not as a result of the Section 27 referral. Now, when Advocate Johnson was here, we put it to her the fact that this entire Section 27 referral seems to be a concocted plan anyway. You have a member of parliament receives those documents mysteriously. Then there's ministers, chief of staff saying this is a Section 27 referral. Then suddenly he pitches up there as well, right? If you could come to the conclusion, and I don't expect you to, but if it was said to you that the Section 25 referral was part of the plan, it was concocted to be like that, hence it lands on Advocate Johnson's lap, would you accept that?
No, definitely not. And that is why I again urge, there is a review process open. That would be totally unacceptable.
What are you refuting, Advocate? That it's concocted, the Section 27 referral, as in these people that we may think, right, are fighting back. It was not just because remember, the member got these documents anonymously, and then he went everywhere, ran to Orlando, went to the Western Cape, somehow finds himself in the minister's office. The chief of staff tries to intervene, until the referral gets to Advocate Johnson's desk. I'm not accusing her. If that whole thing, for it to get there, was part of the fight back plan, right, would you then have a different view in terms of how the case has come about?
I'm trying to understand your question properly so that I answer it properly.
Okay, let me try again. You said Advocate Johnson
I do think I understand it. I'm just reflecting on it, because my understanding is that if the Section 28 referral was part of a fight back plan, and you're not saying Advocate Johnson is part of that, would it then what's your question after that?
Would you still view the case in the same light?
In the light of it's a justified case. Look, it's a difficult one, because if it's part of we should never prosecute people because it's part of any fight back campaign. But the way you frame it is there may have been others that had some ulterior motives and not the IDAC. So the IDAC is looking at it purely from a perspective of criminality. And they come to a conclusion that there is criminality that needs to be prosecuted. Then I would agree that if there is, on the evidence that the IDAC has, that there's evidence that this is in fact part of a much larger strategy to extract from crime intelligence, and it's part of a number of cases, then I would say as long as the evidence is there, it would justify a prosecution. And the manner in which the evidence was obtained is something that is separate from that. But where there's a fight back and people manufacture evidence, and then it's and there's no evidence and the IDAC then acts on it, that is completely out of the question.
Okay, I think I have time just for two more questions. The referral to IDAC that you made around that suspended prosecutor, I mean, without going into detail, but are they moving as speedily in that matter as they did with the Lieutenant General Khumalo matter?
That's a very complicated matter. Because it's an NPA staff member, I've urged them to move with speed on it. But I'm not sure. It's, as I said, it's at the level of intelligence that we received. And so there's going to be a lot of work that needs to happen in that investigation. But they are certainly regarding it as a priority matter.
Okay. Advocate Batohi, this is almost really the last question, I think. So nobody is, well, I'm not disputing Advocate Johnson and how you characterized her as a woman of integrity, right? And I think what you said was that there has been lapses, and I want to ask now, you as her direct supervisor, when you hear these issues that are being raised by General Mkhwanazi as well as former Minister Bheki Cele, where they want to intimate that Mr. Johnson doesn't have a good relationship with Khumalo. He stands in line to maybe be appointed head of CI should he go. Then all these issues around all these issues around how this entire case come about and what is happening, unfortunately, with now Advocate Johnson being brought into this matter. Would you not think that at some point there's a reasonable apprehension of bias on the side of Advocate Johnson in this matter? And how are you, as the NPA head, ensuring that whatever is happening there, I mean, she explained to me that there's a team investigating, but that there's impartiality in the handling of that particular case?
With all due respect to those that have made these allegations, I think we're dealing with allegations on both sides. And why would we choose allegations from one source to be more credible than what Advocate Johnson is saying? And so from what I know of Advocate Johnson, I would not suspect that there's any bias. And because of the circumstances of how the IDAC came to investigate this matter, I have no doubt that it is not motivated by bias at all.
Okay. So, last question. I would have loved to ask you at the end a nice sweetheart question, asking you to reflect about your last 5 years or 6 years at the NPA, but I don't have time. So just know that my intent was there to give you that question. But you said you don't want to sweep things under the carpet. There will be consequences. And I think you were talking about this matter. Now, Section 28 of the NPA Act, I think as amended, still reads, an investigating director may investigate a specified offense if they have reason to suspect that one has been or is being committed. They are required to investigate if the national director refers such a matter to them. Now that you have become aware, Advocate Batohi, that Honorable Adams obtained classified information that he was not entitled to have, which on its own could be illegal, will you then direct Advocate Johnson to investigate that matter as Section 28 demands you to. It may not fall within her direct scope, but what she said when she was asking, when she was responding was, you know, they don't go 90%, 70% of a matter. Would you ask her to then investigate that? Because this section says you may direct her to do so.
I will have to consider this matter if there is a complaint, but I don't have enough facts at my disposal now to say that it's something that I will do. And whether it's something that will also fall within the mandate of the IDAC, I don't know. So it will be something that perhaps the police might be better placed to investigate, also given the limitation of resources in the IDAC. But if there is a complaint, then certainly one of the investigative agencies can investigate that matter.
Thank you very much, Advocate Batohi, and let me thank you once again for your service to the nation. I hope that you'll enjoy your retirement. Thank you, Chair. I'm done.
Retirement is a tax event. I don't intend to stop fighting the good fight.
So much. Can I note hands for follow-up questions? Honorable Malema, Honorable Ngola, Honorable Shongwe.
Thank you, Chair.
Before you start, it's only 3 hands, honorable members. Thank you. You may proceed.
Advocate, the agrees matter was, when it was offered 204, it was in the interest of justice, right?
Yes, that's correct.
And the interest of justice is public interest, right?
That's correct. Generally, that's
so
what
it is correct to say Agrees' decision was based on the public interest because justice is public interest.
That's a good question.
Because she asked you earlier about whether Agrees' matter decision was based in public interest. You said no. But that which is in the interest of justice cannot not be in the interest of the public.
Public interest would generally be in the interest of justice, but interest of justice doesn't always require a public interest aspect to it. So in this case, my understanding was that it was certainly in the interest of justice, but public interest in the way we the criteria that we consider, my thinking was that it was not a public interest matter, but certainly a matter relating to the interests of justice. So I think there is a slight nuance to these two concepts, but they're very, very closely related.
Oh, it is in the interest of public because we might have looked at it now as being in the interest of justice, which might have those problems in relation to public interest. But what Agrees is going to give us is what the public is interested in.
That's
and therefore this decision, it is in the public interest.
I think you're correct. It might well be in the public.
I must get honorary advocates, you see.
I think a doctorate for that.
Now, the last question I must ask, Chair. I know there are so many factors which were considered when 204 was offered to Agrees. But one of the factors is that he's so sick that he can't even appear in court. How is he going to appear in court to give us evidence against these big fishes who are looking for?
We are looking at, not in this particular case, but in other instances where witnesses can testify via video link in cases. So that could potentially be a solution in this matter as well, where the witness is unable to come to court. We're looking at increasing the use of technology in certain circumstances so witnesses are able to testify remotely. So that is an option.
Yes, because in the public interest, I wouldn't want to hear that when he's supposed to appear to give testimony against that which he committed to give it to us in the 204, we are now told he's unable to do so because he's sick. So as long as you are saying you've got those other things in consideration, that we can use the technology to get him to testify from wherever, that makes me be at ease. Thanks, Advocate.
Thank you very much.
Honorable Ngola.
Thanks, Chair. Just one issue. Are the acts of Advocate Johnson in relation to the employment of her husband an error of judgment or a pure case of nepotism?
Given the way Advocate Johnson explained the process, I would be inclined to say that it is an error of judgment of a young prosecutor at the time. As I said earlier, it's something that we should not do. So I would say that it was an error of judgment on her part at the time. But she explained the process. It's still not ideal. And I said as much to her. So I would say it was a serious error of judgment on her part. Perhaps due to inexperience of the time, I'm not sure, but it's an error of judgment. Given her, yeah, I'll leave it at that.
No, Chair, I'm done. I'm fine.
I want you to look at me and say so.
Yeah.
Honorable Shongwe.
No, Chair, thank you. I was covered by Honorable Malema on the Agri's issue. But I may use this time to add something. Advocate, you said while you were speaking to Honorable James, she asked you pertaining Mr. Herman Mashaba, and you promised that you will urge Mr. Mashaba to furnish you with certain documents on that issue. May I also add that you asked Mr. Mashaba that why did he hide documents or hid document or information from the former public protector? Remember when he hired Sibiya, it was then when Mr. Sibiya came with a letter from public protector that cleared him, the first letter. But he was playing smart if he hid the second letter where the public protector asked that Gauteng hired Mr. Sibiya and hid that information about Mr. Sibiya of not passing his competency. So when you're doing that, whatever you're going to do with Mr. Herman Mashaba, please ask him why did he hide information and why did he hire Mr. Sibiya while he didn't pass his competence? Because we are here in this mess because Mr. Mashaba hired General Sibiya, then Mr. Sibiya. Thank you very much.
Just a quick one, Advocate. When he says Gauteng, he means Johannesburg. So we villagers mix the two.
You want to say Joburg Metro?
For the record, Joburg Metro.
Yeah, because he's right. Where we come from, that is the understanding. Ijoni. Do you want to comment on that, Advocate? The point that has been made.
It would have been
by
good if the honourable
Shongwe.
member could raise it with him directly himself, but I take the point and we will.
You're going
I've got
there,
no
you might
further
as well
comments
carry mine.
to make on that, Chair.
Thank you so much. Honorable Skosan,
Thank you, Chair.
your time starts now. It's 9:30, 1 minute past 10. You must be done.
Thank you, Chair. Once again, thank you, Advocate. I'm going to start by making some remarks and quick, answers on that, if you may, please. One, is Bulelwa Makeke still working with NPA? Because there was an issue about his qualifications that she has a diploma, but it came up that it was a 2-week certificate from Damelin. And we were told that it was an error. And the last time I heard that, in fact, she was promoted to be an acting deputy director general. I'm not sure whether it's true.
Well, firstly, she is part of the NPA. She's still with the NPA. I am aware that during a process for the recruitment of someone for the post of DDG, she applied, and that's when the issue of her qualifications came up. And my understanding is that there was a confusion about the SAQA requirements, and so at the end of the day, she didn't get the position, and it's going to be re-advertised. But there were challenges about whether what she had done actually met the criteria for consideration as a diploma or not. And we were getting conflicting versions from the entity that is actually required to give us the correct answers. But my understanding is that the issue has been resolved and that the report that we received was in fact not an accurate report.
A follow up on that. If NPA can allow that a person lies on when she made that application and there's no consequence management, there's nothing happened to her, am I right?
Nothing's happened to her, but there's no indication that she lied. My understanding is that the report was not accurate.
So in other words, are you saying she did not set on the application that she has a diploma instead of a 2-week certificate?
I don't have the precise details of this, and I'm finding it difficult to give you the accurate answers. But my understanding is that the matter has been resolved. It was not an accurate report. And that's as far as I can take it now at this point.
I'm not happy with that. That response, honestly speaking, is protecting one of your employees. You know, in Afrikaans, they say, elke jakals, vrees sy eie sterk. Now, I'm saying, advocate, the issue of Bulelwa is not a minor issue. It's not a minor issue. Don't take it for granted, because you are the examples of ethics. You know, for young men and women, you must set an example that you don't lie. When whether it's at 83, whether it's at 24 or 1, when you are given an application, you must tell the truth about yourself. Now, she can't say it was an error. It can't be an error. If you have a 2-week certificate, you must just say that I've got this in two weeks' time. No, not in a year. You know, it is not a diploma for 2 years or 3 years. You know, but let's let me give you a benefit of a doubt, because you say you are not sure about that.
I do have a response on this, and that is that I've been informed that she did not lie, and that the matter was investigated by our OEA office, and that it has been resolved through an investigation that she did not lie.
So was it a 2-week certificate or a 3-year diploma?
I can't give you the details of that. What I can tell you is that it was a matter that was investigated by the OEA, and it was found that she did not lie. I want to make that very clear, that is the position. She did not lie.
Advocate, I think we must pass that. Otherwise, we're going to take 10 minutes. I ask a simple question now. Was it a 3-year diploma, a 2-week certificate, a 1-year diploma? What was it? Then we can pass that, please.
I want to say that I don't know, but what I can add to help the honourable member is that the matter was investigated, and I'm informed that there was even a lie detector test that was done for security vetting, and it was confirmed that she did not lie.
Advocate, I said to you earlier, you know, we had a witness here. And my colleague ended General Sibia about this competency he was talking about. Have you passed that or you haven't passed that? You know, if you know the answer, how he responded, you'll be embarrassed. But let me just pass that. It looks like you don't want to tell me the truth about this, whether it's a 2-week certificate, whether it's a year certificate or a 3-year diploma. But you say because he was vindicated by your internal structures, it's fine. We'll get to that. Number 2, you know, there was an issue from Honorable James about you not responding to emails. There's a gentleman here in Cape Town. He comes to Parliament here. He sent us emails, which is sent to you. You never responded. The name is Fikile Bambi. He said I must mention that clearly. Have you ever responded to his emails? Many of them.
I should explain that when any communication comes to me, I immediately send it to the relevant part of my office, the deputies, to deal with it. And we have, as a matter of process, that at the very least there must be an immediate response acknowledging receipt, and there must be, as soon as possible thereafter, a substantive response to whatever the matter is about. I don't know about this particular matter and whether it was responded to or not. But if you give me details, I can assure you that he will get a response within the next couple of days.
Thank you. Thank you. I'll forward that to you. On your statement, paragraph 22, if it's sufficient evidence for NPA that they must prosecute, unless it's not in the public interest, what constitutes the public interest and who decides that a prosecution where evidence exists is not in the public interest? What criteria are you using on that?
So, as I indicated earlier, that our prosecution policy indicates that when considering whether a matter is in the public interest, we take into account relevant factors, for example, the nature and seriousness of the offense, the interests of the victim, interests of the broader community, circumstances of the offender, and it was, you know, there has to be compelling reasons to not prosecute. Our courts have actually pronounced on this, that there must be compelling reasons to not prosecute in the face of what they refer to as formidable evidence against the accused. So there's no closed list in terms of trying to establish what are compelling reasons, but there's guidance that is provided in our policy. It could also be that the matter is a trivial offense, as I said, dealing with the gravity of the offense. The accused might be very young or might be very old, or tragic personal circumstances, as I mentioned earlier.
Now, I think you have heard about the so-called rogue unit within IDEC. I think you've heard about that.
I heard about the allegations.
And there were names there. They say Perumal, Sunesh, Sunel, the other one, I think, and the prosecutor called Tyler Shabalala. Do you know him?
I do know him. It's Silas Shabalala.
Shabalala. We are told that he's prosecuting people as well, as far as the Eastern Cape, besides in Gauteng. Is that the norm?
It depends. I need to get details. There are cases where a DPP of another jurisdiction can give delegation to prosecute to a prosecutor from another jurisdiction, depending on the circumstances.
Yeah.
But I don't know about the individual cases, but it is possible legally.
That's how people are perceiving this thing. That to say, some of them in particular, I gave you only one example. That when they target people, there's the rogue unit works with a particular prosecutor to go all over and target people. It's an allegation. I'm just giving you that there's that perception out there that this is how the rogue unit operates.
Firstly, I'd like to be very clear. There's no rogue unit in the IDAC. And if the honourable member has any evidence to that effect, I would really like to have that evidence.
Thank you.
I would urge that we do not make bald allegations without any evidence to support it. I would welcome that evidence because as a national director, I would not want people that are behaving contrary to our code of conduct in the NPA. So I would really welcome that evidence.
Thank you. Thank you, Advocate. We had that before at SARS, where there was Lockenbeck, Lakey, Pillay. We had them. They were rogue. But obviously, as I said, I don't want to invoke again to say, their principal was rogue as well. But it's a debate for another day. But you can't say people must not say, wait, Advocate. You can't say to people that they must not call others rogue because you believe they are not rogue. But if some people believe they are rogue, they'll call them rogue. I mean, there's nothing wrong with that. You believe they are innocent, there's no rogue, it's okay. But some people who are feeling the pain, who their lives are destroyed by the same people, alleged, they will call them rogue. It's not me who's calling them rogue, but I'm just saying to you, they are being called rogue. But for the sake of progress, because we've been ventilating this matter and you're going to take another 5 minutes to respond, and the chair will say my time is over. And I still have another 6, 7 questions for you. I understand Advocate Johnson as well said the same thing we are saying, that there's no rogue. And General Kumalo said there's rogue as well at IDEC. And there's some in the judiciary who are compromised. You will deny that, it's fine, because, you have to protect your staff anyway. But let's move, Advocate.
Chair, I do ask that I be given the opportunity to respond to this.
You're going to respond the same as Advocate Johnson. You'll say that there's no one.
Honorable Kosan.
There's no chair.
Yes, but I think we should not allow, nature doesn't allow vacuum. the chair has had to go out to respond to some emergency. So I suggest that.
Thank you, Chief Whip.
Yeah, so.
Chair, may I answer?
Yes, that's what I wanted to suggest.
Thank you very much, Chair. I think that, the case, I've got confirmation that Silas Chabalala is in fact in IDAC and he has got national right of appearance. That means if you appear I didn't realize he was a prosecutor in IDAC. If you're a prosecutor in IDAC, you're in the office of the national director and you actually have national jurisdiction to deal with that.
Thank you.
So he is completely within his rights to do that.
Thank you.
And the second aspect of the fact that there are rogue elements in the NPA, in the IDAC, I would again urge that evidence to this effect be presented. And if the honourable member has evidence that these persons are bringing cases targeting
Can you
people.
protect me, please? Because she already responded on that. We are going back again there. She's going to give me the same response she gave me 5 minutes ago. Please. You said that. Can we move, please?
Chair, these are serious allegations. I'll be very quick. I just urge the honourable member to please give me evidence of this so that I can deal with it. Thank you.
Coming to the issue of these so-called agreements, because I see a lot of big companies, when they are corrupt, they pay back the money. They are not prosecuted at all. I can give you names: McKinsey, some APP, and others. They just pay back the money. They are not being prosecuted at all. Now, which means now we are not equal before the law. If you don't have the money, you'll be prosecuted. If you have the money, you'll pay back the money. Now, the issue of Vincent Smith and Angelo agrees.
Chair, sorry, can I respond to that issue?
No, I want to give you two, please. Otherwise, as I said, Chair, unfortunately, when he responded, I can't force her to respond, yes or no, because she takes 5 minutes. And for me, I'm asking for 1 minute, and it takes 5 minutes to respond. Now, Section 105, A plea and sentencing agreement vis-a-vis 204 witnesses. I just want to find in terms of racial lines. In terms of states, how many white people were accused and how many black were accused and how many coloreds were accused and how many Indians were accused in terms of racial lines who were given the same agreement, these sentencing agreements, ever since you've been a national director of public prosecution. People who, like Angelo agrees, who were given, suspended sentence like they were given by court. But I'm saying this plea agreement, in terms of, because I've never seen, or perhaps I'm ignorant, in terms of racial lines, is this only exclusive for white people, or anyone can get that? You can plead.
Anyone can get it, and I can attest to the fact that I've done many cases where we've had Section 204 witnesses that were not white.
High profile?
There were, years ago, certainly important cases, murder matters. So I would like to say that it's not something, the issue of race does not come into consideration. I don't know that we carry statistics on that, so it will be unlikely that we'd be able to give statistics on that. But I want to assure the member that the important aspect of 204 is the ability to get evidence to prosecute a case.
Okay.
And sometimes if it's insider evidence, for example, you have to withdraw against certain witnesses and use them as 204 witnesses in order to get to the bigger fish.
Is anyone from Steinhoff who's prosecuted as we speak, and how many people were prosecuted on that matter?
I think the CFO of Steinhoff is in custody currently, and I think he's a white male. Of course, we know that Uster committed suicide. There are still investigations continuing in that matter.
Sissoko, a chief investigator at IDEC, we were told that he was hijacked. I think last Friday, if I'm right. Is it true?
That's correct.
Was Robert McBride right-hand man? Was he Robert McBride right-hand man?
I have no idea.
Was he not having a proximity to Shedrack Sibia, or Paul O'Sullivan, or Benjamin Chauke?
I do not know.
You don't know. Now, I've been hearing that, most of the things you distance yourself, you say you don't know. It's fine.
I really don't
Paragraph 25, Section 179 of the Constitution provides that the NPA must exercise its function without fear and favor, like you said. Remember? If this is so, why has the NPA not prosecuting the case of Phala Phala, where the president was hiding foreign currency in sofas, far in excess of what the exchange control regulations allow? Because Advocate Johnson said the matter was not brought to her. Now, as NPA, what is your stand on the matter of Phala Phala? Besides being that the matter is classified.
If there is evidence against any person in the Phala Phala matter, there must be a prosecution. That matter, I explained earlier, there's two aspects to it. The one aspect, accused persons are in court. The other aspect regarding the money in the sofa is a matter that was declined by the DPP and is currently under review.
If I may ask about the DPP as well, who was doing that case. Does she has the clearance is being a clearance certificate? Is she vetted?
I don't know if she has top security clearance, I can get that information, but it doesn't affect her ability to do her job.
No, I'm not saying it affects. I'm asking whether does he have a top secret certificate or was she vetted?
I don't know. I'll have to check the list.
But do you vet them or all the NDPP? I mean the DPP?
We certainly ensure that we are fully compliant and that all the necessary steps are taken to ensure that the State Security Agency can conduct the vetting. So we are fully compliant in the NPA.
Now, you said that for some people, if they ask, that you are raising a lot of issues, but you raise them very late because we are about to go. In the report of the Zondo Commission, the State Capture Commission, because you've been talking about the Zondo Commission a lot, was that report which was handed over, you said is in the department, was it peer reviewed? If it was peer reviewed, by which institution? Because a lot of people are taking the matters for a review. Some of them who were fingered, they are cabinet ministers as we speak. Now, I just want to find out, because it looks like we rely more on that Zondo issue.
So before I answer that question, I have confirmation that the DPP in Limpopo does have top security clearance. On the second issue, on the question that the honourable member raises now, I'm gone blank. What was the second question, with all due respect? Oh, the peer review.
Yes.
Thank you, Chair. I'm not sure what process the honourable member is referring to when peer review is mentioned. I can't comment on that.
Yeah, what I mean that report, remember, as I said earlier, that a lot of people who were fingered are challenging it. So I'm asking that after the report was handed over, was it peer reviewed?
I'm not aware.
Sure. Now, my last one, because my colleague asked for another 6-7 minutes. At paragraph 69, you speak about Zondo Commission report and say NPA was not spared of being captured. I've read that report of Zondo Commission. Can you refer us to the page where Zondo says that?
Sorry, which paragraph is the honourable member referring to?
Paragraph 69. You said Zondo says the NPA was captured. My question is, how was it captured? Who captured and by who? That's my last question, Chair. Because I've tried it. That's what you said. So I wanted to find out. Maybe you can.
To clarify, if you read my statement, it says that the Zondo Commission heard testimony relating to the capture of the criminal justice system, not that there were any findings. Regrettably, as I testified earlier, there were no findings made. And we certainly hoped that the Commission would have made findings about this. So unlike SARS that had the Nugent Commission, for example, the Commissioner was able to act quickly on findings there. But
yes,
with regard to the NPA, we had hoped that the Commission, because they had heard a lot of testimony around the capture of the criminal justice system, that they would make some findings around it. But these findings were not made. And so I just want to be clear that I didn't say that Zondo Commission had made findings, but we certainly hoped that they did. Regrettably, they didn't.
Thank you, Chair. I was reading your paragraph, but unfortunately, Chair, my disappointment is that the advocate, when he's talking to us here, there's somebody who's sending him electronically answers. and it's disappointing. It's like you have your legal advice. I'm not talking to you. We are responding on someone who's sending you answers. Thank you, Chair.
Chair, I'm trying to assist the committee in giving them accurate answers and as full as possible. Thank you, Chair.
That is the information you did not have and you had to get it. Honorable Nomvalo, your fellow comrade has left you 4 minutes.
4 minutes. So I'll try to be very quick.
Chair, I didn't answer the question on.
And I would request the witness to give short answers. I will also try to give short questions.
Chair, if I may, I didn't answer a question about the corporate alternate dispute resolution mechanism.
Just note the question. He does not have time.
Okay, thank you, Chair.
The chair will give you time to respond to the question.
Advocate, is it possible for a matter to be withdrawn on the basis that the NPA still wants to add more people as accused people, or for the matter to be struck off the roll because they still want to add more people?
It is possible.
It's possible. You said you don't know Paul O'Sullivan, eh?
I said that I don't think I've met him, but he has sent emails.
Have you ever heard about him playing a certain role in the work of the NPA?
No, I haven't.
Do you know that there's a case, there are charges which were laid against him, and I don't know whether he was arrested, but before COVID, and charges were later withdrawn, or the matter was struck off the roll on the basis that more accused are to be added. Are you aware of that?
Not aware of that case.
Yeah, I know that I will always get such answers to you from you because you are not too much involved. You are not executing your statutory obligations, like I said. That is why you don't know. Can you make us a favor, because Paul O'Sullivan is a subject in this investigation, and we really want to know what happened in that case, because he was charged, as per the information that we have. He was charged and later arrested. The charges were withdrawn, or the matter was struck off the roll on the basis that more accused people are to be added. And that happened before COVID, either in 2019, 18, or 17. So if you can give us a report in that case, is that possible?
If I can get the details, we'll certainly.
Yes, and tell us the status of the case, because we are saying we don't know what's happening.
Sure.
Currently. Then the next thing, if I captured you correctly, you said you only heard once, or you only received one report in relation to the work of the PKTT. Is that correct? Did I hear you correctly?
No, I said that the DPP provides reports, and it may have been included in the reports that the DPP sends, but specifically a report relating to PKTT. There was a report when the Minister Kele had raised some concerns about the conduct of prosecutors working with the PKTT, and then the DPP compiled a report in that regard specifically.
Yeah, so for the prosecutorial work that was done by prosecutors who were involved in the PKTT, you never made any supervision.
That's the DPP's role, to manage the operations.
No, let's not go there. If it's your role or the DPP, I'm asking now, if you never made any supervision, did you make any supervision of the work that was done by prosecutors who were involved in the PKTT work?
That's the DPP's role, and
so you never made any supervision.
That is the DPP's role.
No, you never asked for any report.
There was no need for me to ask for a report. The DPP is the one that was engaging with the PKTT, and her evidence at the Madlanga was that they were working well with the PKTT.
No, leave the Madlanga.
Unit.
I'm talking about during the course of the work of the PKTT, when they were busy doing their work. Have you ever summoned any report on progress of the work that the prosecutors were doing?
As I explained, it appears that things were working well with the PKTT and the DPP. So I did not ask for any reports on that matter.
Now I understand why you said, when I asked you about the case of Sindiso Makaka, you said you do not know. It's because you never even tried to involve yourself in the work of the PKTT, which involved prosecutors who belong to your organization.
I did explain at the beginning the role and powers and functions of a DPP and the role and functions of a national director. It's really important because these are operational matters that the DPP manages and is expected to, as very, very senior and powerful people in the NPA, to do their jobs, and that's what they do. If there's a risk and there's a need for a report, of course, I would ask for reports intermittently, but not for the sake of receiving reports if things are working fine.
Yeah, no, I'm no longer going on that one because I think we'll never agree. I thought we were agreeing, and I've just learned now that we're not agreeing because we are going back to the same position. Now, the last one, I asked about the unjustified delay, according to me, of matters which delay for more than 5 years. Like I cited the what's the name, the Zandile Kumete case, and I think there is a matter which has delayed for 8 years or more, which relates to the former Minister of Police, Minister Pashane, who was charged with something which is related to blue lights and so on and so forth. Now, where do we locate the interest of justice in that regard? Or the former commissioner? Thank you very much. Now, where do we locate the interest of justice in such delays? Are we still pursuing the interest of justice in a case where a matter is delayed for more than 10, for close to 10 years?
Through your Honourable Chair, it's not in the interest of justice, but one needs to look at the reasons for the delays. And as I explained earlier, there may be instances when prosecutors are responsible for delays, but in the majority of cases, I have asked for reports. We get many reports from Parliament, parliamentary questions, asking for delays with regard to specific cases that have gone on for years. And in the majority of them, the prosecutors are not responsible. It is the defense, it's the accused, it's for legal representation. There's a whole range of issues, for example, where lawyers withdraw from cases, and there are very, very few cases. So when we do say it's not in the interest of justice, I agree completely it isn't.
Yeah, but
it's very rarely the prosecution that is responsible.
Yeah,
for
I'm
it.
sorry for interjecting, but I'm talking about an instance where a delay is as a consequence of the NPA, where they keep on postponing the matters, like in the Zandile Kumete matter.
In that matter, there've been numerous reasons why the matter's been postponed. And there are some reasons at the instance of the prosecution, but they cannot be completely blamed for the 8 years of delay, because there are various reasons why the matter was delayed over that period. And if we really want to look at this matter, we need to look at it holistically and not selectively. Why the case was delayed for that period
No,
of
the
time.
chair is saying I'm running out of time. What?
Yeah. You have been riding on the benevolence of the chair. Advocate, there is that other question which you noted, you said you wanted to respond to it.
Chair, just to mention that with regard to the corporate alternate dispute resolution mechanisms, that this has been a mechanism by which we have been able to recover billions for the fiscus. I want to be clear that even though the corporate entity is the one that the agreement is reached with, it does not include individuals within the entity. And part of the agreement is that the corporate, which is the company which is paying, will actually cooperate with the prosecution to ensure that individuals are prosecuted. So no one's actually escaping accountability. It's a win-win situation because we're able to get the money back and also ensure that we get cooperation, that individuals in the company are able to be prosecuted and held accountable.
Thank you so much. Can I note hands for follow-ups? Your hand must be down, Honorable Scosa. You can't ask a follow-up on your own line of question. No. No. Yeah. You see, we allocated you 30 minutes. So you are indivisible. Whether you shared it between yourself is one speaker. And that speaker is either Honorable Nomvalo or Honorable Scosa. The only person who can ask a question from your part, if there is Honorable Shongo. The two of you are indivisible. Now, as we speak, Honorable Malema, Honorable Ngola, I don't see any hand. The list is closed on those two speakers. Honorable Malema.
Advocate, was Jackie Slavy's case not a high-profile case?
It was a high-profile case.
Was Leonard Lord not given 204?
Beg your pardon?
Leonard Lord, was he not given 204 in the Slavy case?
I don't know. I'm not aware.
Remember that Leonard Lord was accused, or you don't know the case?
I know it, but at a very high level. I don't know the details of who was given.
No, it can't be high level. It's public information. I mean, if it was details which are not publicly known, I wouldn't know about it.
I'm
You're not aware that Leonard Liotti was...
Agliotti, I'm
Yes,
sorry, I
yes.
did not, and my apologies, I didn't understand.
No, the problem is that you are quick to say, I don't know, even when you don't hear the question. That's a problem.
The name was not clear, and I thought, who is this person?
Yes.
I certainly didn't
Was
know.
he
But
not given 204?
I think he was, I'm not sure.
Yes, he was, in exchange for
Agliotti.
slavery.
That's my recollection from the publicly available
So
information.
it will not be for the first time in a public case like a greasy given 204 in order to catch big fish
Certainly, it's not the first time.
in a high-profile case.
That's correct.
Thank you.
Are you done, Honorable Member? Honorable Ngola?
Is he done or he doesn't know as well? Chair, just one issue from me. So in TBP 2018, the government of South Africa establishes the PKTT. You get appointed the National Director of Public Prosecutions in 2019. The year you get appointed at the height of political killings in South Africa. In 2023, the Interministerial Committee extends the existence of the PKTT. 2024, 31st December, the minister issues regulations disbanding the PKTT. 6 July 2025, a provincial commissioner takes to the public issues and alleging that NPA is colluding with the drug cartels. Later than that, the Madlanga Commission summons the Director of Public Prosecutions in KwaZulu-Natal. Later that, the Ad hoc Committee of Parliament invites you to come and appear before it in relation to that. But still you have not seen a need to solicit a report from the DPP on the effective contribution of the NPA in respect of political killings.
The evidence of the DPP was that they worked well with the PKTT, and in her testimony during Madlanga, in the Madlanga Commission, she said that...
Can I interject you respectfully,
if I could
NTPP? Leave what the DPP said in the Madlanga Commission. I'm giving you a series of events that would have forced or coerced your hand to request a report from the Director of Public Prosecutions in KwaZulu-Natal. Now, I am saying, in light of all these incidents from 2028 to now, you have not seen...
From 2018.
2018, sorry, Chair, thanks. From 2018 until now, you have not seen a need to solicit a report from the DPP in KwaZulu-Natal in respect of the contribution of the NPA in the political killing system.
With respect, Honorable Ngola, it's important what the DPP said at the Madlanga Commission. She said that the prosecution and the PKTT worked extremely well together. And that was her testimony, that they're working well together and that she's satisfied with their work. So I'm not sure that, you know, what a report would have achieved, given that she was satisfied with the working relationship and, in her view, the success of the PKTT.
How did you assess the contribution of the NPA in the work of the political killing system if there is no report submitted before the Madlanga Commission?
As I mentioned, that this was an operational issue that the DPP was managing, and there was no issue that that resulted in the DPP having to submit a specific report about the fact that there were challenges or there were any issues about performance relating to the PKTT. And then she testified that the PKTT was working fine with the prosecutors. So that in that assessment, there was nothing untoward. There was, if of course she had said that things were not working out, it would be a different scenario. But in these circumstances, there was no need to solicit a report from the DPP in terms of the NPA contribution to the PKTT work.
So you would only be required to request a report if things are not working out?
Not necessarily, but generally that happens more frequently, that reports are requested. But where there are high-profile cases, specific cases, DPPs are requested to report at regular intervals without being requested a report.
So as things stand, you are not aware whether NPA has in a particular way sabotaged the work of the PKTT?
That the NPA has any way?
Has in any way or to whatever extent sabotaged the work of the PKTT?
From what the DPP in KZN says, they worked extremely well together. And the evidence of Advocate Johnson indicates that she didn't even know about the fact that the head of crime intelligence was involved in the PKTT. It did not feature in the work with regard to these arrests. So in my view, in my opinion, I'm of the view that there's no sabotage by the NPA of the work of the PKTT at all.
Thank you so much. What is half a second, Honorable Skosana?
Thank you, Chair. You know, Advocate, I've been sent to give you a farewell of disappointment. They are saying, I must say to you, you failed the sense of your family. Your prosecutors have failed the sense of your families and many families, not necessarily him alone, but his case has been going on for many years, and people who were supposed to be, in their view, to be held accountable, they are untouchable. May you please, before you leave the office, encourage your prosecutors to do the right thing. This postponement, as my colleague was talking here about,
The time has expired.
so the half second is gone. Please, can you please consider that? Thank you so much, Chair. Thank you, Advocate.
Thank you, Chair. May I respond? I will try to be quick. Chair, I will not sit here and accept the blame on the part of the prosecutors for the absolute disaster in the prosecution of the Senzo Meiwa case. I can give details of the fact that there were two teams in the police that were investigating this matter. One reporting to the minister, one reporting to the national commissioner. And these teams were at loggerheads with each other. If I recall correctly, I stand to be corrected, there may even have been dockets open by one team against the other. It was a total mess. There were requests by the teams for specific prosecutors from the Johannesburg office. There were allegations that against certain prosecutors. And in an effort to salvage the case, I discussed the matter with the DPP of Pretoria and Gauteng and said, we're going to take this case out of Johannesburg and transfer jurisdiction to Pretoria, get a prosecutor from Pretoria to look at both the dockets, at all the evidence, and decide on how to proceed and unravel this total mess in this case. And so that is what happened. But that was done by the NPA in an effort to ensure that the victims in this case got justice. And it's something like that should never happen in our criminal justice system. But it did. Thank you, Chair.
Where you work, Advocate, is there a CEO or a DG?
A CEO or in the NPA?
Or a DG?
No, Chair.
So in your position, you act like you are the Director General of the NPA in terms of the organizational hierarchy.
No. Well, Chair, I hope I understand you, but the National Director is not the accounting officer of the NPA.
Who is the accounting officer?
The Director General of Justice.
So the staff of the NPA reports to the DG of Justice and not to your office.
You have raised a very important point, Chair, because legally speaking, a large chunk of the NPA staff derive their legal authority from the DG of Justice. And it puts a national director in a weakened position to properly run an organization.
Because what I want to understand is with regard to the recruitment of staff, who does the recruitment of staff at the NPA?
Chair, we do the recruitment of staff in the NPA. We do have an HR capacity that deals with the recruitment of staff, but there are various levels of approvals, certain levels of, depending on the level in the NPA, the process happens in the NPA and the final approvals go to the Department of Justice or to the Minister, depending on the levels.
So the person who is a chief director, or let me say the DTG at the NPA reports to you?
Legally speaking, would report to the DG of Justice, but is in the NPA, which is a complicated and not an ideal situation.
Yeah, I'm asking this because Honorable Skosana asked you a question about the qualifications of one of your senior managers, whether the person is appropriately qualified or not. And for sure you'll agree with me that it has been very difficult for you to respond to that question.
Chair, I didn't have all the information, but when I did get it, I informed the House that that matter had been investigated, and the allegation was that this particular staff member had lied about her qualifications, when in fact that was found not to be the case.
Yeah. And unfortunately, the matter of the Senzo Meyiwa case also came very, very late, because I know when General Sibia was here, the committee was very, very incisive. And it was like we were chasing a blind man's path. We couldn't get the answers that, an answer like the one that you have just given now, to say that there were two parallel teams and seemingly working against each other. And you can imagine, in a case like this one that has generated a lot of public interest, it's a decade now that the case is still unresolved. And we get an information like this one 10 years later, that this is what happened. I mean, you know, for people who have suffered injustice for many years, I don't know which superlative we use to describe the situation like this one. But there are many other questions which I may not enumerate one by one. And maybe what we may have to do as a committee, because some of the questions, when you responded, you said you did not know. We may have to send them to you so that we can get details of those. Let's say we will give you a benefit of doubt that when you came here, the NPA is a very large and complex institution. You would not know decisions which would have been taken in the Eastern Cape or in the KZN or in other province, because my understanding is that there is a DPP in any of the provinces responsible for taking those decisions, and matters can only come to you when they come on review. So if we can send you those questions, so that if you have to follow up with your colleagues at those levels or elsewhere in the institution, we can get comprehensive responses that can help the committee to do its work. Because it was said by you here that the reason why you are here is because you feel Parliament has a role that it can play to strengthen the criminal justice system in the country. So the IDEC is your entity, it reports to you.
That is correct. It's in the NPA and reports to the National Director.
And then when the head of IDEC was here, Advocate Johnson, she says they investigate, they prosecute, and they also pass judgment. Is that so?
They certainly investigate and prosecute, but not pass judgment. That is done by a court of law.
They don't pass judgment.
They investigate and prosecute.
And then after prosecution, they take a report to a court of law.
The case would be tried in a court of law, and then the judge or magistrate would make a decision and pass judgment.
So if I appear before them for prosecution, how does it happen? They prosecute me in the absence of a judge.
It's not possible. The prosecution can only take place before a judge.
That's
in a court of law.
exactly what I want to understand, because it appears like it's a separate process.
They are separate processes, the investigation process and a decision to prosecute. Let's put it this way. They investigate and take a decision to prosecute. The prosecution happens in a court of law, and a judge makes a final decision.
So when they investigate, do they work with the police under the supervision of the police commissioner?
Before the IDAC became permanent, that was the position. now that the IDAC is permanent and they're able to recruit, their staff will now report. There may be members from the police that are recruited as well, but they will report not to the police anymore, but to the head of IDAC now that they are permanent.
So the investigation and the prosecution is not separate. It's done in one house.
That is correct. It's the prosecution-led model that is being followed in the case of IDAC.
So if they investigate the mass effect arrest, they also do the arrest.
That is correct. They do have powers of arrest.
Where do they get the warrant of arrest?
They have to make application to a judge or a magistrate.
And then who plays oversight on IDAC?
Honorable Chair, as I mentioned earlier, there is the IDAC is part of the NPA. The normal processes relating to investigation of allegations against NPA staff members would apply. But as an added layer of oversight, or a complaints mechanism has been established, and a judge has been appointed where people can make complaints to the judge, or IDAC can itself make complaints to the judge in the event that there's improper influence being brought to bear on members of IDAC. So that's an added layer that still needs to be brought into operation, although a judge has been appointed.
So it's only one judge. It's not an arrangement like an ombud.
It's one judge. That's correct. Okay. Similar to the DPCI situation.
But this kind of arrangement, advocate, for the purposes of principles of natural justice in law, do you think it's okay to do things like that?
In terms of having the prosecution, the investigation and prosecution.
Yeah, you have one institution that can run activities like that.
Absolutely. It is in fact an international good practice to have prosecutors, investigators in this prosecution-led model to ensure that there's better, well, there's no need for collaboration. You have everyone in a team under one roof, all the capacities, capabilities, and it actually lends itself to more efficient way of investigating and prosecuting. The prosecutor-guided model, which is the police and prosecutors separate, is generally the traditional way of doing it, but it doesn't always give us the good results that we would like from the model.
Yeah, because that is the question I'm going to, whether is this not the incubation of tensions that are there between yourselves and, because I mean, tensions are palpable between IDEC and the police. Is this not the incubation of tensions?
In any situation where you have certain entities that have powers to arrest and prosecute others, and if they do execute those powers, it could lead to tensions. And I think that is what we are seeing here. But it doesn't mean that the model is wrong and that we shouldn't be looking at capacity. And in fact, organized crime, maybe we need to have, given the scourge of organized crime in this country, we need to look at what do we put in place to ensure that we're able to get to grips with organized crime. The current construct is not working.
Look, my imagination and the wildest of the imaginations is if the general of intelligence is going to do work somewhere and then he's called by IDEC to say, no, you must stop everything because we must arrest you. He must go and do work somewhere. Then other institution in the criminal justice system is calling, no, Kumalo, stop everything. You must be arrested. Yeah.
Honorable Chair, if people are in positions of authority, there are allegations against them, and that the law must take its course. That is what the rule of law is. The law must take its course. Then that will be a consequence of that action. But of course, we need to put in place mechanisms to ensure that the entity is able to function efficiently, notwithstanding that.
Look, I'm sitting here, I'm trying to understand the complex interplay between the police, IDEC, and you still have other one in the equation, IPIT. Yes. So that is exactly the kind of the question I'm asking, to have a better understanding whether you need to make necessary interventions in law or in policy, so that there can be a streamlined way of how this, in terms of your institutional arrangements.
Chair, I think we'll all agree that we have a crime crisis in this country, and the current situation is not working.
Yeah.
And we need intervention, strong institutions and entities that can deal with the crime situation. And there's enough crime, sadly, to go around for specialized entities to be able to focus on particular crime types, as the IDAC does with regard to corruption.
And then an ordinary South African who is aggrieved feels that they deserve justice and they are not getting it. Will they be wrong if they conclude that you spent a lot of time in turf wars than dealing with their issues? Will they be wrong to conclude that way?
Chair, they would certainly be. There's no turf wars, Chair. It is the IDAC executing its mandate, which has clearly made people unhappy. But that would be a consequence of enforcing the rule of law. And we will have to, as a government and organizations, deal with the consequences of enforcing the rule of law, which the IDAC has done in this case.
But did you listen to the generals of the police when they were here? Because they are not saying what you are saying. And the public listened to them. The public is today listening to you, coming from institutions of the same democratic state, saying different things. Will they be wrong to conclude that way?
Yeah, it's not a question of turf wars. As I said, the IDAC is an entity with a very specific mandate. And it appears that in execution of this mandate, there are certain people that are not happy about the consequences. And this has resulted in, it's not really turf war, because it's not like the two sides are trying to deal with the same cases, which will result in a turf war. But it appears to have resulted in tensions, because the conduct of the ID is not is seen by certain persons to be something they should not have done. So it's resulted in unhappiness. But I wouldn't categorize it as turf wars in this case. But it's certainly, there's unhappiness about the conduct, the arrest of the head of crime intelligence and others.
Let's see.
Thank you, Honourable Chair, Honourable Members. I just want to go back to an issue relating to the high-level intelligence that you received, and which involves a prosecutor in the NPA. Do you recall that?
Mm-hmm.
And your initial answer was that this prosecutor was under suspension. I then asked you, and you didn't have to answer it because it wasn't a DPP. who would have to be suspended by the president. And this particular person was not suspended by the president. And the reason that you advanced for not wanting to disclose that prosecutor's name was because the matter was under investigation. Now, if that prosecutor was under suspension, that prosecutor, you'll accept, would be entitled to know what the reasons were for the suspension.
That is correct, but I must explain that the suspension does not relate to this particular case. They are two separate cases.
Well, that is what I wanted to understand, because I had also asked you, well, if the suspension doesn't relate to any of these Nkwenazi allegations, then what was the reason for not disclosing the person's name? Then you said no, but the person was also being investigated for those other reasons, the high-level intelligence that you received, but that the person was not even aware of it. That was this morning. And later, we were told, and the reasons that you gave were then accepted by the committee, was that this person is not under suspension and was being, but because the person was being investigated and was not even aware of the investigation, that to disclose that person's name would jeopardize the investigation.
That is correct, Chair.
Yeah, but it seems to me that there's a difference in the reasons that you gave earlier today and the one subsequently. I can understand that someone is being investigated, is not even being told that he or she is being investigated, because it may jeopardize the investigation and jeopardize or threaten the lives of potential witnesses in the office, etc., etc. But that's not how it came across earlier.
Chair, it may not have come across, but that is the fact, is that the person is not aware of this particular investigation, but is under suspension for another matter.
So the person is under, because what I wanted to then conclude on is that if the person is not under suspension and is being investigated in relation to a really serious issue that you got at a high level, and this person is still working, so the person is not working.
That's correct.
Okay. Then just moving on to the Khumalo issue, much has said that what triggered Lieutenant General Nkwenazi's 6 July media appearance and statement was a directive that disestablished, or that purported to disestablish, the PKTT, issued on the 31st of December 2024 by the minister, the then Minister Mkhunu. And before that, there was also a raid on Molefe on the 6th of December, which also involved the PKTT. And then subsequently, Lieutenant General Nkwenazi had asked the minister to meet with him to discuss this directive to disband, and he was ignored. And subsequently, he then requested an affidavit from General Masemola, the National Police Commissioner, to give him an affidavit relating to the directive, which, by the way, we're still waiting for, and that was given to him on the 4th of July. And all all those factors informed his decision to go public on the 6th of July. Now, were you not aware of any of these events?
I wasn't.
Okay. Because another theory is or might be, because this is all about, and that's what we're trying to do, and the committee is trying to put everything together, so-called joining the dots. Did the arrest of Lieutenant General Khumalo on the 28th of June, which you were aware of, did that perhaps trigger the media statement of Lieutenant General Nkwenazi, that this was in response to his arrest on the 28th of June?
Chair, I can't make that conclusion because I don't know what triggered it. But those are the two facts that we have. But I don't know. I cannot comment on that. I really don't know.
Now, you had said in your evidence earlier that Advocate Johnson had discussed this Khumalo issue with you at a high level. Is that right? Now, two things arise from that. If the allegation was made, if it's true that this arrest of Lieutenant General Khumalo was actually to aid this drug syndicate in the work that they were doing, in some, I must say, perverse way, and you were aware of his arrest, then you would be complicit in it, isn't it? I mean, that kind of logic.
If I was aware that the reason why the IDAC was proceeding with the case against Khumalo was in order to protect organized criminals, then yes, I would be complicit in that.
The other aspect that arises from that is, what now happens when there is a review, which in the ordinary course will come to you as the NDPP in relation to the Khumalo case or the Khumalo arrest, when you had already discussed this at a high level, even at a high level with Advocate Johnson, would you not have to recuse yourself? Are you not biased one way or the other in relation to conducting a review of that matter?
Chair, and that is precisely why I get very high-level reports and not the detail of evidence. A review is a very intense process whereby the national director looks at every aspect of the evidence and makes a decision. And that is why it's only a high level. So I do not express support for it in the sense of I'm aware of the evidence and that, you know, I have sanctioned it, so to speak, because then it would mean that I could potentially be biased. And so there's absolutely no conflict. And that is why we have really made sure that even though we put in place systems and processes, and there may be instances where the national director asks for reports, I do not go into the detail of evidence so that when there is, if there is a review, I can act totally objectively in the matter and assess the evidence objectively.
But Advocate Batohi, we also know that there is a thing called, in law or in legal circles, institutional bias. Why would you uphold a review based on a complaint by an accused when Advocate Johnson has already discussed this matter with you at a high level? She's a colleague of yours. They do important work. Despite the fact that you now have to do a more detailed analysis of the case and go really into the, roll up your sleeves, go into the facts of the matter and so on, why would you want to rule, as it were, either uphold or reject a review?
Because I take my oath of office seriously, and I know the implications of a person being wrongfully prosecuted. So it may not be a situation that a DPP has made the decision incorrectly. It could be reasonable minds could differ and a different approach. So there have been instances where I have overturned the decision of DPPs to prosecute. And so it happens. And, you know, I'm, as a national director, I'm expected to ensure that, you know, my oath of office is important. And as I said, our prosecutorial decisions are powerful and they have impact on the lives of people. And we must make sure we get it right.
Hopefully you understand that I raise this as a genuine concern.
Understand that.
In the same way that IDEC investigates and prosecutes. We know of many instances, probably best seen in the movies, where prosecutors manipulate investigations. They manipulate, or they ask specifically for certain evidence because they want to prosecute successfully a person, either for ideological reasons, political reasons, or for reasons that they want to nail this person. That also is a possibility arising from this model.
We've seen that in our country even without this model. Yeah. So it can happen, and it has happened. That's why we have these processes like review processes to ensure that these things the risk is minimized. But of course, that is
because
possible.
I think that's the issue. It's the risk, given that I think you've accepted and this honorable committee has heard how divided our police force is, and that now the head of crime intelligence has been arrested. The extent to which it has paralyzed our crime intelligence, we don't know, even though an acting person has been appointed. But the head of our crime intelligence is not allowed to go to his office. He can't access the work that needs to be done, although he has not been suspended. So that risk seems to me even bigger.
Chair, it would happen.
It's a comment. If you want to
Sure.
comment on it, you may.
No, then I would prefer not.
You would rather not. It's late. Just lastly on the, again on Khumalo, it seems to me well sort of accepted that he was arrested because a complaint was laid by Honourable Member Adams from some information that was apparently slipped under his door. But we also know from the evidence that there were 6 dockets because he complained here in Cape Town, he complained in Gauteng, and he was frustrated because he wasn't getting a response. And eventually he wrote to the minister. And the minister then referred this matter to IDEC. And Adams, Honourable Member Adams, he then referred the matter in terms of Section 27 of the Act. And that triggered this investigation. But what I want to ask you the fact is, however, that Lieutenant General Khumalo was arrested in relation to a docket and a different case number that was opened at the Brooklyn police station. It's not any of this. There were 3 Cape Town dockets, 3 Gauteng dockets. None of these dockets. Can you explain that? Is there a reason for that procedure? And that the docket, sorry, just to complete, to be fair, the docket is opened in June, hence his arrest on the 25th of June. It's opened only in June. These are dockets that were opened in November. The complaint, the Section 27 complaint came in November, went to Advocate Johnson on the 16th, I think, of November for further investigation. She then requested further documentation from the National Police Commissioner. This was in January, but then a new docket gets opened in June. Should we read anything into that? Is there anything sinister in that? Anything unusual?
From my recollection of what Advocate Johnson said to me, and I cannot remember the details, she seemed to suggest that there was something sinister about it. And I would propose that, she submits that in writing to the committee, because the details are rather intricate and I don't understand it. She understands it better, but that was the impression that I got.
The Honourable Committee has, and in fact, we were told that Honourable Member Adams had submitted another affidavit which she styled or called a supplementary affidavit. But when I pointed out to her that, the detailed charge sheet with a summary of the facts that you give to an accused person, I said, but there's no reference in the charge sheet to any of the 6 dockets. Anyway, we've requested that affidavit, and I think it was sent today, and we haven't had a look at it.
She said she's not going to send the referral to us. She can't.
Yeah. Thank you, Advocate Batohi. Thank you for your cooperation. Thank you for your time, and all the best for the remainder of your time in office.
Thank you. Thank you very much, Council.
Thank you, Honourable Chair.
How many days are left in office, Advocate?
I'm not counting the days. There's still a lot of work to do.
Okay, Honourable Sols.
Chair, if I may, I just want clarity on the extradition matter of the Gupta brothers.
Let's do like this. Can I check, honourable members, because this is unconventional, that we allow a person to ask a question at this stage. So if we open it, honourable source, I must check if there are other members who want to speak. I'm going to humbly request you to make that written submission together with those other members who will have questions that would not have been adequately responded to.
But I like the way your office operates, Advocate. They're very quick here. Once someone asks you a question, they're
Thank you.
very fast.
Thank you so much.
Not all the questions. There's
Thank you
questions
so much,
that I need detail.
Honorable members, SC and Advocate Mokhaitz. Thank you so much. Thank you so much, Advocate Batohi, the NDPP and your team, the staff of Parliament, and the staff of political parties that is still here with us. We want to thank you so much. We have come to the end of today's proceedings. We are coming back here again on Thursday. We are starting at 9 o'clock on Thursday. Thank you so much.